Next up is House Bill 25. Chairman Todd. Chairman, you're recognized.
Thank you, Mr. Chairman and committee. This bill creates a process for defendants to assert civil immunity that they already have, doesn't change their immunity, or they may request a stay of any civil proceedings related to a criminal proceedings until criminal proceedings have been concluded in a self-defense situation. We had this bill last year and fully vetted and passed, and I have worked with members on this committee. I've worked with Chairman Carter quite a bit on this, as well as another committee last year to make sure we got this crafted properly, and just affords people that already have immunity in our law the ability to have a stay put on that on a proceeding so that they don't have to fight two battles at the same time in the legal world, both criminal and civil.
All right, members, you've heard the explanation. We do have someone who's requested to speak, Jason Sparks from Moms Demand Action. So we're going to go out of session and listen from him. Mr. Sparks, you're recognized.
Thank you. I'm Jason Sparks. I'm a resident of Nashville. Good morning, and thank you for the opportunity to speak today. I'm here today to ask this committee to oppose House Bill 25, which would expand Tennessee's stand your ground law. 4 years ago, I lost my best friend of 36 years, my baby brother, Christopher Sparks. Even though he was 36, he had really just started life. He had spent most of his 20s working in restaurants and had recently gone back to college and gotten a degree in mathematics and physics. He moved to Nashville to be closer to us and gotten a great job with the Tennessee Department of Labor and Workforce Development in Metro Center. It was wonderful. He was there for every birthday party, soccer game, dance recital. He was always there for my kids, who were 7 and 5 at the time. We had a special relationship, and though we were different, we were best friends. On September 28th, Chris had taken his lunch break to drive to his home in the Nations to walk his rescue dog, Dawson. Along the way on Rosa Parks, he spoke to someone driving erratically. That person shot him at the next intersection, 2.5 miles from where we are right now, and drove off, leaving him to die alone in his car. To me, this bill is about the right of survivors to seek relief when they choose, which is a vital feature of our justice system. House Bill 25 is unnecessary because Tennessee law already provides immunity from civil liability for people who lawfully use force, including deadly force. This bill would allow the shooter to request that the victim or victim's family delay filing a lawsuit until the conclusion of a criminal investigation or prosecution. If the shooter does not request that the lawsuit be delayed and the victim files a lawsuit, the shooter can then request an immunity hearing to establish that they're immune from a civil suit. So, for example, the person that shot my brother could have claimed that they were just standing their ground and defending themselves and delay my family from ever getting any civil justice for years until the criminal prosecution was over. Delays, it would be re-victimizing the victims, essentially. So delays like this discourage gun violence survivors from taking those who unlawfully use force to civil court, blocking the right to timely relief at the time when they're most vulnerable. Why would Tennessee want to do this to its citizens who are victims of violence? Survivors know they'll never get their loved ones back. What we want is justice and the knowledge that the perpetrator will not harm someone else. And we want recompense for the pain and suffering, for the counseling for our children, for funeral costs that we weren't expecting or ready for. We can never return to what we had or to what we were, but we can move on. Without your help on this bill and others like it, we can't even do this in a timely fashion. It galls me to know that there are laws like this being proposed when it will make harder for my family and others to achieve justice when people are potentially irresponsible with their guns. That's
fine. Thank you, Mr. Sparks, and I'm sorry for your loss, and thank you for your testimony. Members, do we have any questions for the Chairman Farmer?
And thank you, Mr. Chairman, and thank you, Mr. Sparks, for being here. I know it takes courage and to share your story, your loss, and we are all extraordinarily sorry for your loss. Something that never should have happened. It's a tragedy. And also, I wanted to apologize to you personally. I think I overlooked you last week. Certainly wasn't intentional.
I
chair the subcommittee, but I want you to know we're about transparency and making good policy here. and we would never intentionally leave somebody off the list to speak. So I wanted you to know that, and my sincere condolences for your family.
Thank you, Chairman
We're
Farmer.
praying for you.
Appreciate it. Thank you.
Thank you, Chairman. Any more members? Seeing none, we'll go back into session. Chairman Todd, you're recognized.
Thank you, Mr. Chairman. And while I share the same condolences that have already been mentioned here for the Sparks family, and I've heard this testimony twice in the last couple of hours, and I do share their sincere pain in that. As he stated, defendants already have immunity in this state. This doesn't change that at all. This just simply gives a person the ability to put a stay on a civil proceeding until a criminal investigation takes place and is adjudicated. And as we all know, most of those are done very, very quickly, sometimes within hours, sometimes within days. But in the right situation where a defendant has used force to defend themselves, and we have that right to do right already, then they're not going to be fighting two legal fronts at the same time, which one could jeopardize the other. And that's all we're trying to do here, is to protect law-abiding citizens. The perpetrator that has been mentioned in testimony already was a criminal. There's nobody here that would defend that person for their actions. So we're not defending criminals here. We're defending law-abiding citizens. Thank you, Mr. Chairman.
Thank you. Members, you heard the explanation. Any questions? I think Clemens beat you to it there, Parkinson. Representative Clemens, you're recognized.
Thank you, Mr. Chairman. And Representative Todd, I just want to get clarification. This legislation would require the stay until the criminal action is completed. Is that correct?
Recognized.
Yes, sir, that is correct.
Okay, so I just want to get clarity. A second ago, you said this can happen in a day or a week or something along that timeline. I've never seen a criminal case for, let's say, a murder be resolved in a day or a week. So I just want to ask you to clarify that or get some clarification from that in case you misspoke or in case I misunderstood you. Thank you.
Thank you, sir. And I'm certainly not an attorney. And, I see things that happen on TV. I see cases where someone defends themselves, and all I was referencing is some of those more simple situations where it's really obvious it's a self-defense situation, and there are no charges brought. So that's all I was really referring to. Obviously, there are cases that would apply to this and would have a significant longer time, could be months. And again, I'm not in that realm, so I don't really know how those tend to take, how long those tend to take or how they are processed. But I appreciate that clarification.
Yeah, well, thank you. I appreciate that. And I oftentimes I wish that the legal process played out like it does on TV and as efficiently and as fast sometimes, but often that's not the case. So that's one of my concerns for this. So thank you for clarifying that. Thank you, Mr. Chairman.
Representative Parkinson.
Thank you, Mr. Chair, and thank you, Chairman Todd. I'm a little bit conflicted on this bill, and the reason why is because I agree with you that a civil case could possibly sway a criminal case, but I also where I part ways with you respectfully is in the assertion that, or the assertion that these are law-abiding citizens. We won't know if they're law-abiding until after the case is over with, and they may be found innocent or may be found guilty, and then we will not have been under this legislation defending a law-abiding citizen. And so, but I get it, because even this in regards to civil asset forfeiture, and I'm not trying to go down a rabbit hole, Mr. Chair, but I feel the same way about that. You taking property from someone before they had a chance to be heard in the courts. And so I just wanted to, just get out what was in my head to you. That's all, So, but thank you again, and thank you, Mr. Chair.
Chairman.
I would certainly agree to you, innocent until proven guilty. And so that's all this does. It protects those that are innocent. Certainly, the criminals are going to be prosecuted, and then they will certainly be, that civil situation will be dealt with in another court.
Follow up, go ahead.
Thank you, Mr. Chair. Under this legislation, it wouldn't be an automatic stay, would it? Would a judge would still have to approve the stay, am I correct?
You have to request it, and then a judge would order that.
So, but does the bill say that the judge shall or may? How does that work?
Thank you, Mr. Chairman. I believe a judge shall, but it's under certain circumstances. You have to meet those actual circumstances in the law. So they're doing an assessment, I believe, of the immunity that the person already has under law, and then they would apply that stay.
Okay, but there's not really any discretion for the judge to make that decision. I'm sorry, and maybe you can explain what those factors are, if you don't mind. And I just want to get just a little bit more clarity.
Okay.
Jeremy?
Yeah.
I'd be glad to. If a plaintiff files a civil action against a defendant based upon the same facts or events that the criminal situation, the defendant may assert in any responsive pleading or by motion in writing pursuant to the rules of civil procedure that, one, the defendant's use of force or threatened use of force was justified and permitted by existing law. The defendant has immunity from the civil action pursuant to the above described present law provisions. Because of the defendant's immunity, the claim does not state a cause or of action upon which relief can be granted, and the defendant requests an immunity hearing to determine if the civil action should be dismissed for reasons. So there is another avenue even for that. If the immunity hearing is requested or ordered, the court must expedite the hearing, hear the matter, and issue a decision within 40 days of the hearing being requested or ordered. From the time the hearing is ordered, all aspects of and procedures relating to the civil action will be stayed. All applicable parties must be given notice authorizing such parties to appear and present evidence at the hearing. And there's already provision in the rules of the court to preserve evidence. That was another concern we had, and it's been expressed before. And we wanted to make sure that no evidence would be lost, because we don't want anyone's rights infringed upon here. We want to make sure that everybody has their day in court and that their interests are protected. So that's already, fortunately, again, I'm not an attorney, but that's what our research has shown from all the documents and the other attorneys we've consulted on this had involved in this.
So,
Mr. Parks?
thank you, and thank you for that. That gives me a little bit more clarification. So there is still some discretion in there in the judge making that decision based on if he feels that those criteria are met or not met. Am I correct?
Yes, sir. That is correct on dismissing the case. Yes, sir.
Thank you, Mr. Chair. Thank you, sir.
Representative Griffey, you're recognized.
Thank you, Mr. Chairman. Thank you, sponsor, for bringing this legislation. I fully support it. This legislation kind of tracks what the feds do normally. In federal court, if there's a civil action that's also got criminal charges, the courts typically, there's presumption it'll be stayed, and we'll deal with the civil side after the criminal matter is resolved. For the main purpose, you really don't want what the outcome of any civil stuff to impact someone getting a fair jury trial if there's criminal charges involved, because you were talking about somebody's possible imprisonment and so forth. So you want to make sure that's based solely on the law and the facts that are brought to the judge in that case. And this doesn't alter the universe, other than it says things will be put on hold. So at some point, they're going to get justice on the civil side. We just need to let the criminal side go first. I think that's the smart approach, and I support this legislation. Thank you for bringing it. Thank you, Mr. Chairman.
Yes, sir. Well, I got one more. Representative Garrett, will you withdraw? Or the questions have been called. Will you want to withdraw and let Garrett speak, or Rush? Okay, yeah. Representative Garrett.
Thank you, Mr. Chairman, and thank you, Representative Bricken, for that. I want to go over a situation where I had a client, and I want to make sure this is one of the intentions of your legislation, Chairman Todd. I fully support it, but I want to make sure that I understand that what happened to me, this would prevent my client from potentially violating or getting his Fifth Amendment rights violated. I represented a fellow in a divorce, represented the husband, and he was charged during the pending of this civil action putting a GPS monitor on his wife's car, that's a misdemeanor. That's a crime. Can't do that. So the slick lawyer on the other side decides to try to take my client's deposition. And in that deposition, I bet you can probably guess the very first question of that deposition is, did you put this GPS monitor on this car? What does that do? Boom, invokes the Fifth Amendment, because what are you going to do? Say yes or no, and you've implicated yourself, which you're guaranteed not to do under the Fifth Amendment of the Constitution, right? So in that instance, if he said that and invoked his Fifth Amendment right, that implies something to put that into testimony, and then you can bet your bottom dollar that that civil testimony, the deposition, is then going to be used in the criminal matter to say, what did you say about that in your divorce case that had nothing to do with the criminal matter that's concurrently going on while his civil trial is going on? Some slick lawyer will use that against that to violate, unbeknownst to you, potentially your Fifth Amendment right. Is that the intent of what this bill is trying to protect? So in both matters, in both civil and criminal court, you are guaranteed a fair trial, which you are guaranteed under every constitution in the United States.
Chairman.
Absolutely, sir, and I appreciate you bringing in something that's similar. Obviously, it's not a self-defense situation, I don't think, from your description, unless I misunderstood, but it is the same principle, exactly. We do not want your expressing your rights in one case to potentially violate your rights in the other.
Thank you for that clarification, Mr. Chairman. Mr. Chairman, thank you.
Very good. Any other questions from members? Seeing none, we're going to be, question's been called. Without objection, we're going to be voting on sending House Bill 25 to calendar and rules. All those in favor say aye. Aye. Those opposed? No. The ayes have it. You'll be going to calendar and rules, sir.